Good afternoon, everyone, and welcome to today's webinar hosted by Region 8 chapters of HFMA. Today's webinar is titled, Privacy, Security, and Breach Notifications. Is your organization ready for HIPAA Phase 2 audits? Before we get started, I would like to review a few housekeeping notes. All phone lines are on mute to avoid interruptions during the broadcast. In your audio panel, you may select to listen to this broadcast using your computer's mic and speakers, or you may select telephone to receive a dial-in number. To access a copy of the presenter's slides, simply expand the Handouts panel located to the right of your screen and select the PDF file. At the conclusion of today's presentation, we will have a Q&A session. However, you may submit your questions at any time by typing them into the questions panel also located to the right of your screen. I'd like to welcome today's guest presenter, Barbara Pritchett, who is Business Solutions Consultant for Revenue Cycle at Craneware. Barb is a registered nurse and has more than 31 years of healthcare experience. She specializes in performance improvement, quality and risk management, conducting operational assessments, corporate compliance program development and review, as well as mock surveys and policy and procedure development. Barb has more than 12 years of experience in survey readiness, coordination, and resource designed to meet requirements for regulatory agencies. So before I turn the call over to Barb today, we are going to kick off today's event with a poll question. We just want to get an idea of our audience today. So it's a very simple question. We just want to know who on the call is comfortable with Phase 2 knowledge and your level of comfort. Are you just learning about the tool? If you feel like you have good processes in place today and are prepared for it, or if you've even been through an audit already, we'd love to get your feedback there. So we'll just pause for a couple seconds while we get some of those votes in, and then right afterwards I'll share this with everyone so we all can take a look here. All right, looks like about 70% have come in, and those results, looks like you have the perfect audience here, Barb. So about 70% are just learning. And then about 22% feel pretty good about the processes that are in place today.
Well, perfect. So we'll go ahead and get started on that. Our objectives for the day are determining the status of your organization's HIPAA policies, procedures, and compliance plan, review the process of the OCR in regards to the HIPAA Phase 2 audits and action steps that your organization can take for audit readiness. Reassess your organization's process of obtaining business associate agreements and determine the status of your organization's business associate agreements as you prepare for the HIPAA Phase 2 audits. We're going to go over some definitions because I think that that's always a good place to start. There are some who may be very familiar and some of this language may be brand new. So what is HIPAA? So in review, part of the federal law of HIPAA is the privacy rule, and that contains provisions regarding the privacy of protected health information, or PHI. Now I always like this slide. Congress enacted the administrative simplification provisions of HIPAA, and that's part of Title II on this slide. And what it is it's to promote efficiency in the healthcare industry through the use of standardized electronic transactions while protecting the privacy and security of health information. And that kind of makes sense. So the Secretary of HHS adopted standards, and those standards relate to the administrative, technical, and physical safeguards as it relates to ePHI, electronic healthcare transactions and code sets, privacy of protected health information, security of electronic protected health information, and unique health identifiers. So as we move forward, so we talked about HIPAA, so now what is a covered entity? So a covered entity is either a healthcare provider, a health plan, or a healthcare clearinghouse. And you can see on this slide, feel free to, to use all of the information here, back to your organizations as well, is you just sometimes you just need to get where the base is in regards to what is a covered entity. So what is protected health information? And there is a lot, so I put that into 2 slides because sometimes we forget what is all protected health information. Names, birth dates, phone or fax numbers, email addresses, social security numbers, medical record numbers, health plan numbers. And so think about what goes on in your organization. Is there information that's inadvertently accessible for the public to see? Where are your fax machines located at, for example? Are there pictures posted that you're not sure that an authorization has been obtained? If you have staff that are using portable devices, are they their portable devices or are they given to them by the organization? And if they're theirs, how do you ensure secure access and transfer of information? What happens when the device is exchanged? Is the device used by other members of the family? Those are kind of all questions in regards to protection. Do you have staff that have laptop computers or work from home? And is there information on that desktop that could be considered PHI? So in the next few slides, I did want to go over some examples of different kinds of breaches that have occurred. In this case, an unencrypted laptop computer contained electronic protected health information of 441 patients that had been stolen. This 2013 case settlement is really important because it was the first time that a financial settlement had been reached with a covered entity for a HIPAA violation discovered with a breach of fewer than 500 records. Typically, it is 500 records or more that you get into a civil monetary penalty, and this is the first time that it has been less than 500, and they are looking at less than 500 more and more. In this example, Catholic Health Services was a business associate in this case and provided management and information technology services to 6 skilled nursing facilities. And the breach that occurred was a theft of a Catholic Health Care Services issued employee iPhone. So during the investigation, the OCR found that the Catholic Health Care Services, as the business associate, lacked the required risk analysis and accompanying risk management plan. This investigation, in this case, found that the Raleigh Orthopedic released an X-ray films and related protected health information of about 17,300 patients to a group that promised to transfer the images of the X-ray media in exchange for harvesting the silver that went along inside the X-ray film. The director of the OCR in a statement said it is critical for entities to know whom they are handling personal health information and to obtain assurances that the information will not or will be protected. And in this case, they did not have a business associate agreement. In this case, this may be a little bit more well known to some. In this case, New York Presbyterian gave a TV network what appeared to be unrestricted access to its hospital so they could film their series, New York Med. And it was reported that this created an atmosphere where patients and their PHI could not be protected. The director of the OCR said in a statement, in this case, it sends an important message that the OCR will not permit covered entities to compromise their patients' privacy by allowing news or other television crews to film patients without their authorization. Other breach examples, as you can see, it comes in all forms and fashions. The California Department of Corrections, Anthem data breach, and that is from last thoughts that's progressing to trial, Loyola and University of Mexico, San Juan County, and Washington, D.C. So what are the common types of data breaches? Skimmers on your credit card. We now hear of wallets and purses with protection against those machines that can steal your information as people are walking past you without your awareness. We also think about the scams on the gas pumps that when they're altered that they can take your information. In the healthcare world, we think about theft of devices or hacking. We think about weak and stolen passwords. We talk about sending information to the wrong person inadvertently through an email. Internal privilege abuse. Just because you work there doesn't mean that you can access the information. And as we think about that, think about our banking world. Just because a person works at the bank does not give them carte blanche to go looking into your records to see what you've been doing with your money. It's the same thing with healthcare. Just because you work in healthcare does not mean you can access patient information if you have no reason to be in their information. Ransomware. We've all heard about ransomware and the attack of and people being held for ransom in their organizations. And so with that component piece, it's not if they can hack you, it's can you recognize it when they do? Because if we think of all those people, if they would just use their powers for good, life would be better. But it's how can you recognize it, and how long are they in your computer systems? In researching for this, the average dwell time, that's what they call when a hacker gets into your system and then searches around in there. The average dwell time was between 126 and 180 days. So it's not how well can your organization, fight them off, but if they enter, can you detect the breach attempt? Can you detect how long they've been in your system? And can you detect the dwell time that they've been hanging out in there? So caregivers do not come to work planning to break a HIPAA law. But there are 4 categories used for penalty structure. Category 1 is a violation that the covered entity was unaware and could not have realistically avoided, and had reasonable amount of care have been taken to abide by the HIPAA rules. Category 2 is a violation that the covered entity should have been aware of but could not have avoided even with reasonable amount of care, but falling short of willful neglect. Category 3 is a violation suffered as a direct result of willful neglect of the HIPAA rules in cases where an attempt has been made to correct the violation. And in Category 4, a violation of HIPAA rules constituting willful neglect where there is no attempt that has been made to even have a correction of the violation. And it's up to the discretion of the OCR to determine whether a financial penalty within the appropriate range is necessary. The OCR considers a number of factors when determining penalties, such as the time of the violation, how long it was allowed to persist, the number of people affected, and also the nature of the data that was exposed. Also, the organization's willingness to work with and assist in an OCR investigation, that's also really taken into account. So, and a fine may be also put on as a daily basis. So think about if you have, let's say, medical records, for example, and and you've been denying people their right to their access of their medical records with no other reason besides just saying no. And you did that for a year. So the penalty would be based on the day and how many days that you were doing this, not necessarily the amount of people that you were having this information withheld from. So as we discussed earlier, even small data breaches, less than 500, and even small, has triggered investigations. And so if you fail to train and educate someone on HIPAA, that is not enough, and you cannot claim ignorance that you didn't know. So the average cost of a breach. In this slide, the average total organizational cost for a breach was taken from 2006 until 2015. Also note the number of breaches that were reportable had increased from 2006 to 2015. The average total organizational cost was $6.5 million. So think about the total impact. It's not just the fine. It is including operational, financial, and reputational impacts. So as healthcare technology continues to expand and advance, on a daily basis, with that comes an increase in consumer risk and consumer privacy breaches. And that's where the OCR comes into play. The HHS, Office of Civil Rights, enforces the rules, and they're related to the Health Insurance Portability and Accountability Act, which is HIPAA, and the Health Information Technology for Economic and Clinical Health Act, HITECH. In 2011, they conducted a pilot auditing program to evaluate the adherence to HIPAA and compliance regulations. So they just sent folks out to see what covered entities were doing. And that became phase 1. And so let's talk about that and go a little bit deeper into phase 1 and phase 2 audits. So in phase 1, the focus was for the OCR to go out or to hire another party to go out in their behalf and to look at covered entities, big and small, chiropractic, dental, hospital, all different kinds of covered entities, and to really look at to see if they were following the HIPAA controls around privacy, security, and breach. And what they found is that they were very much lacking in either A, having policies and procedures, B, having them be a part of the business, or having them be effective and having an overall compliance plan to go along with that. And so from the findings, they developed protocols. So I wanted to give you the website for the protocols. So you have that in your bucket. And so there are 180 protocols that they devised. 89 are around privacy, 72 are around security, and 19 are around breach. And so when we talk about the numbers of protocols, you can see the importance of privacy is evident with the amount that we're having here. Now the primary purpose, according to the director of the OCR, the primary purpose of these audits is to help us all learn how we can work together to best protect information that we hold. So moving into phase 2 audits, these began in March of 2016. So after they went through the phase 1 audits, they built the protocols, and now they moved into the phase 2 audits. And some of you listening in the audience may have already been asked to provide contact information or fill out the questionnaire. And so at the beginning, the OCR, when they were looking for the right contact person, and so they wanted to send the information out. Know that not finding the right contact person did not dissuade them from sending it to the covered entity site. From there, they were asked again to fill out that pre-audit questionnaire. And again, big facilities and small facilities were included in all the covered entities. 167 covered entities were selected randomly to then perform the audit, the desk audit and on-site audit if needed. So failure to respond to their questionnaire didn't dissuade them from coming and asking for your information. Now, moving forward, we know that they're not going to end this process, but they will be continuing into 2017. So for those of you who have had leadership changes, or for those of you who still have those leadership emails, make sure that you're checking them every now and again to see that, to see if they're sending you some information, because they want to get the correct contact information, and what they have may be from someone that is no longer in your organization. Those that were selected were notified by email and letter requesting documents. And the expectation of the organization is to send the response within 10 days from the date of the letter. So what is the status of your organization if you are asked to provide this information? So let's talk about that a little bit. If you have been, or in the future, chosen for an audit, you can't prepare anymore. It is what it is on the day that you receive your information. So like, you can't go and update all your policies, or you can't change your policies and then send them in within 10 days. It has to be what it is at the time that you receive your letter. If you don't get the information sent in the 10-day time frame, and you're outside of it, just don't not respond. You need to send it in as much as possible. However, you won't receive credit for the late documentation, but you're providing it in good faith. And you need to explain the why if you don't have information that they're requesting. The desk audit will be focused around protocols from the privacy rule, the security rule, and the breach notification rule. And entities will be audited just on those compliance areas. Desk audits, based on findings, may turn into an on-site audit. When the on-site audit occurs, they want to focus on those in 2017, and auditors will review the organization compliance and HIPAA controls that are in place. The first round was concentrated on the covered entities. In September of 2016, the OCR announced it would also be auditing business associates, and those business associates were notified in October of 16. And what they did was they looked at, when they were looking at the covered entities, they asked the question, can you please show me where your business associates are? And from there, they chose those business associates to go and review. And so what they wanted to find there is, do the business associates have the same protections in place that the covered entities do? So the goal for the audits are, they want to identify best practice, what's happening out there. They want to go beyond just enforcement reviews, and they want to see if there's trending things. What are things that we need help with as a covered entity that they can assist with? And if there's concerns that the OCR can provide tools with or other things to help with compliance. And they want to drive organizations to be proactive in their compliance and to mitigate breaches. So if a desk audit is done, the intention is not for it to be an investigation. It can turn into one based on of what they find, but that's not the intent. If they're on site, they have an entrance conference. They're on site for about 3 to 5 days. It'll be more comprehensive than a desk audit. They'll write a draft report. You've got 10 days to review. They'll share the final report in 30 days, and they'll share the report with the stakeholders. So let's talk about the desk audits a little bit. In the desk audits, the scope is going to be around 7 controls from privacy, security, and breach notification rules. Now I put those on the screen here. So in the next few slides, we're going to go through them in a little bit more detail and the protocol requests and audit inquiry that will be expected if they ask you for this information. So the first one is the Notice of Privacy Practices and Content Requirements. As an example in the privacy rule, the Notice of Privacy Practices and Content Requirements, like we said, is one of the controls. Review your policies and procedures. Are they consistent with the criteria that you have in place to verify the identity of persons who request PHI? Review a sampling of your documentation. How did you verify the identity of several recent requests of those who want to look at their PHI? Do it at the beginning of the year, do it in the middle of the year, just do a little random sampling. Does the documentation include a copy or a notation of the official credentials of someone who requested? Do you have a completed verification checklist? Do you have a copy of the request on official letterhead, for the request of information, etc.? Provision of notice, the electronic notice. Does your organization maintain a website, and does it prominently post this notice? So observe your website to determine if the Notice of Privacy Practices is prominently displayed and available. An example of prominent posting would include like a direct link from the home page to your HIPAA Notice of Privacy Practices. And if you provide an electronic notice, do you have you reviewed your policies and procedures regarding the provision of the Notice of Privacy electronically and the process by which an individual can withdraw their request for receiving electronic notices? If you provide Notice of Privacy Practices by email or other electronic form, do you have a documentation of agreement with an individual to receive notice via email or another electronic form? And if there's been any failures to providing that notice, what other attempts have you used in regards to providing like a paper copy or an alternative means of providing that statement? Right to access. How does your organization enable the right of an individual to access their information? Policies and procedures for individuals to request and obtain access will be reviewed. Do your policies and procedures adequately address circumstances in which your request is made for PHI that is not maintained in your organization? Does the individual's right to access PHI in a timely manner, is that correctly described in your organization's privacy practice notice? A review of requests that were granted and a review of requests that were denied, you want to look at those as well. Verify that the access was provided consistent with the policies and procedures, and verify that requests for access that were fulfilled and in the form and format requested by the individual. Can your organization readily produce PHI in the requested form and format, including electronic format? Was the response made in a timely manner, and was that within 30 days of receipt unless an extension was provided? Were fees charged to meet the reasonable cost-based fee requirement? As only the cost of labor and copying PHI, supplies for creating the paper copy or electronic portable media, postage, and preparing an explanation or a summary report. If you denied access to certain PHI, determine whether it provided access to other PHI requested by the individual that was not excluded. So did you provide some information but not all? And in cases where access was denied, did you review that to make sure that it's consistent with your policies and procedures? And do you have a standard template or a form letter requesting access for protected health information? And if yes, have you reviewed the document to determine whether that includes all the requirements? The security risk analysis. Do you have policies and procedures in place to conduct an accurate and thorough assessment of potential risks and vulnerabilities to the confidentiality, integrity, and availability of all the electronic protected health information that you create, receive, maintain, or transmit? And when's the last time that an accurate and thorough assessment of the potential risks and vulnerabilities to the confidentiality, integrity, availability of all of the PHI that it creates, receives, maintains, transmits has been done? And determine if you've implemented all those requirements. Review your risk analysis policies and procedures. Do they address the purpose and the scope of the risk analysis, the workforce member roles and the responsibilities that they have, management involvement in risk analysis, and how frequently the risk analysis will be reviewed and updated? Review your written analysis records and the documents that show the risk and vulnerabilities. Evaluate and determine whether the risk analysis or other documentation, so you want this to contain the defined scope that identifies all the systems that create, transmit, maintain, or transmit ePHI, details of identified threats and vulnerabilities, assessment of current security measures, impact and likelihood of analysis, and risk rating. So review your documentation regarding the risk analysis or other documents that immediately precede the current risk analysis or other record if you have any. And has your risk analysis been reviewed, updated on a periodic basis in response to changes in the environment, any changes in operations, any security events or occurrences of a significant event? Do you have policies and procedures in place regarding risk management processes to reduce risks and vulnerabilities to a reasonable and appropriate level when you're looking at your risk security management? The security rule compliance practices of covered entities and business associates will be audited against the requirements. These requirements will be assessed based on the overarching principles of the general requirements that pertain to all security standards. Do you ensure confidentiality, integrity, and availability of PHI? Do you protect against reasonably anticipated threats or hazards to the security or the integrity of PHI? Do you protect against the reasonably anticipated use and disclosures of PHI that are not permitted or required by the privacy rule? And have you ensured that the compliance with the security rule by its workforce? And have you trained them well? So you want to review your policies and procedures related to risk management. Evaluate and determine if the documents identify how risk will be managed, what is considered an acceptable level of risk based on your management approval, the frequency of reviewing ongoing risks, and identify workforce members in their roles and their risk management process. Review the documentation that you have demonstrating the security measure implementation and or the process of being implemented as a result of a risk analysis or assessment. Evaluate and determine whether the implemented security measures appropriately respond to the threats and vulnerabilities that you've identified in your risk analysis, and that the measures are sufficient to mitigate or remediate identified risks to an acceptable level. Timeliness of notifications. Were individuals notified of breaches within the required time period? Review your policies and procedures for notifying individuals of breaches and determine whether such policies and procedures, including providing notification without unreasonable delay and in no case later than 60 days of discovery of a breach. Review your list of breaches, if any, the specified period of documentation indicating the date of the breach the individual was noted, the date the covered entity was discovered the breach, and the reason, if any, for the delay in notification to determine whether all the individuals were notified. So the content of the notification. Do you have policies and procedures for providing individuals with notifications that meet the content requirements? And those are listed on this slide. Do you have a standard template or a form letter for notification to individuals for all breaches or specific types of breaches? And if yes, again, does it have all of the pieces that are on this slide? Review your list of breaches, and if any, and the documentation of written notices sent to affected individuals for each breach to ensure that it contains all these content requirements. So what I wanted to show you here, we just went through the 7 pieces that during an audit will be requested. It's a lot of information. It's a lot of showing what you do and what you know in your organization. The next 2 slides, what I really wanted to show you is this is from the Department of Health and Human Services, the OCR, and this is a slide shot of the documentation request. And as you can see, I know it's a little bit small in here, but the first one says it is the timeliness of notification. And the next section is the content of the notification. So they put all that information in there for you to fill out. Here is another one, Notice of Privacy Acts and the Provision of Notice in the electronic notice. So they want very specific information as they're moving forward. The next piece I want to talk about is business associates. So a business associate is not immune from the HIPAA Phase 2 audit. And the HIPAA privacy rule also applies to those identified as a business associate. And they are anyone or person, an organization or a person, who is working in associated with or providing services to a covered entity, who handles or discloses personal health information. So some examples are third-party administrators that deal with the health plan, a CPA firm whose accounting services to a healthcare provider involves access to their information, coding reviews, an attorney whose legal services to a health plan involve accessing information, a consultant that performs utilization reviews for a hospital, independent medical transcriptionist, pharmacy benefits manager that manages a health plan or the pharmacy network, a healthcare clearinghouse that translates a claim from a non-standard format to a standard transaction on behalf of the healthcare provider. Those are all business associates. And as it's just not the covered entity organizations like we spoke of before that will be selected for an audit. This next round, that those were notified in October of 16, will be included in any of the audits. And the business associates need to ensure that they have the same privacy, security, and breach practices in place that the covered entity does. The process of sending letters for contacts may not occur, like we said earlier, because the first round of business associates were chosen from the covered entities of the initial Phase 2 audit. Listing of other business associates may include transcription services. Think about your answering services. Think about off-site records holding companies. Again, think about destruction companies. So in review of the current business associate relationships that you have and executed written agreements, if not already in place, review your current policies and procedures related to business associate agreements to ensure that there's individuals who are monitoring, negotiating, and documenting the business associate relationships. The biggest thing is, do you know who all your business associates are? And do you have a listing of those vendors that have access to protected health information? Sometimes what happens is that you have a business associate agreement that is maybe embedded into another contract. And do you have a current template for business associates agreements? And who reviews them and making sure that they're evaluated for the services that are going to be provided? The biggest thing is, are they up to date? The language has changed. And failure to complete a business associate agreement with a third-party service can result in penalties for HIPAA noncompliance. As an example, in September of 2016, Care New England Health System was fined $400,000 for a HIPAA noncompliance that include the failure to revise their business associate agreement, which was originally signed in 2005. That business associate agreement was updated in 2015, but it was only as a result of the OCR investigation and their corrective action plan. So covered entities not only need to obtain a HIPAA-compliant business associate agreement from all vendors that require access to EPHI, but also ensure that those agreements are regularly reviewed and up to date as language is updated. So we've talked a lot about what is a HIPAA Phase 2 audit. Who are the covered entities? What is a breach? Who is a business associate? So how do you prepare? And we'll talk about that in our next section. The first piece is looking at your compliance plan, looking at your policies and procedures, your standards of conduct. Do you have a designation of a compliance officer and compliance committee? Conducting the training, and the training is for all staff in regards to HIPAA, and then also conducting targeted training where necessary. And when we talk about that is maybe there's specific targeting that needs to be done in HIM. Maybe there's specific targeting that needs to be done on the nursing units. Maybe there's specific targeted training that needs to be done with the physicians or with the billing office. That's the targeted training. Effective lines of communication. In your compliance plan, do you have a hotline if someone needs an anonymous hotline, or what are your reporting mechanisms? What is the turnaround time for completion of an investigation event, and where does that communication go? Standard disciplinary guidelines. If two people have the same issue in regards to a compliance issue, is one discipline different than another based on the exact same thing, the exact same one event? Are you monitoring and auditing? And do they have a standard response to perceived or real events? The compliance plan benefits: having effective internal controls to ensure compliance with statutes, rules, and regulations. There's a commitment to the organizational conduct. And what we mean by that is when you have a code of conduct coming into a facility, it is the staff is saying, yes, the organization has indicated how we are to behave, in regards to our work, in regards to our peers, in regards to our patients. And utilizing that organizational code of conduct on hire so that people know exactly what's happening right away. If there is a performance concern, you can provide that code of conduct again and have it reviewed and signed, and on the yearly evaluations so that folks understand how important the code of conduct is in your organization. It identifies unlawful and unethical behavior and the ability to react to compliance concerns and effectively target resources to those concerns. So having a compliance plan isn't one more program that you have in place. It's like survey readiness. When you're getting ready for a survey, you don't want to ramp up for a survey and then when they leave you say, oh, I'm so glad that's over. Let's go back to what we were doing before. The same thing with the compliance plan. You don't want to ramp up. You want your survey readiness, you want your compliance plan to be just the part of the way that you carry out your everyday business. Having a culture focused on improving quality and efficiency, developing the standard mechanisms to report issues for potential process improvement opportunities or for corrective action, implementing a centralized source for distributing information, a mechanism to streamline internal communication, that is key, and developing a process for early detection and mitigation, because you always want things to be brought forward prior to having it become an issue. How is the board prepared in your organization in regards to a compliance plan? Has the board delegated persons as an oversight to the all-over compliance and HIPAA compliance? Have they a good understanding of your risk assessment results, where the attention needs to be placed, how training has been accomplished, and the results of auditing and monitoring for decision making? And do you bring information to the board at least quarterly? Looking at the essentials, risk analysis, policies and procedures, training. Those are your three key items. Risk analysis, policies and procedures, and training. Identifying the status of your compliance program that also includes HIPAA is the risk analysis. How do you respond to a perceived or actual breach? What's the process for patients to access their own PHI, and are you monitoring the requests? Is the request form standardized throughout your organization? If you've got branch areas or clinics or part of systems, are they all the same throughout your organization? For all who provide PHI to patients, is their access aligned to information from one staff member? Could be the same from another staff member. Are you monitoring turnaround time? What's the process of monitoring your mobile devices in your organization? Are they staff issued or are they using their own? And what is the monitoring of logins or passwords and malware attempts? Does your organization have HIPAA policies and procedures? Is the retainment for at least 6 years? Do you have a process of archiving policies as they're updated? And are the policies and procedures user-friendly, reasonable, and appropriate for the new staff member? I always think of the new staff member. If I was walking into your organization as a new staff member, how easy is it for me to find your policies and procedures? How easy is it for me to ask the questions of how do you follow your policies and procedures? Are your policies and procedures on the shelf with your compliance plan, or are they an active, working part of your workflow and it's the way you do your business? Are your HIPAA policies and procedures compliant with the current regulations? One of the ways that you may want to look at reviewing your policies and procedures to see that they match up against the HIPAA protocol is use the website that I put on a couple previous slides and utilize that. It's already formatted for you. You can add another column and just add your policy numbers right alongside so you can know that you're going to meet every component part of the protocol because you've got your policy right next to it. And anytime that there is an update to your policy, then that policy can be then either linked to that protocol or you have the same number of that policy and that would be the reference back to it. That is a good way to just compare back and forth the protocols to what you currently have. So in regards to a perceived or validated breach, Is there someone identified in your organization who will be notified and conduct an investigation within the 60-day reporting time frame, and if needed, or if you need to, report it to the OCR? Who's that person identified for you? And if you need the full 60 days, please know that the OCR may want to know what your progress was during that 60 days and the timeline of what you did during that time frame prior to your submission. So for tools, this is the Risk Assessment Methodology Flowchart, and it was developed by the HIPAA Collaborative of Wisconsin. And the flowchart was taken directly from the NIST SP 830. Now, the flowcharts and templates, like such as this one, can be shared as long as the statement of credit is given to the HIPAA Collaborative of Wisconsin. And so I want to acknowledge that this is their product. But as you're looking through it, another one is the 866, the Guide on Security of HIT. And so those are two tools, this one being presented, that you can kind of walk through and step through. Now, CMS doesn't require you to use these templates, but they can be useful in the security portion of your risk assessment. So what items do you need to have ready at the go? Your policies and procedures, your HIPAA policies, your job descriptions, your security officer and privacy officer. Looking at your evidence of work in your process. Do you have your HIPAA breach log and the documentation of any mitigation efforts? Do you have your risk analysis summary? Is there any performance improvement activities that you've done? Any investigation processes that you have? Do you have your list of your business associate agreements and your HIPAA training content and your logs and validating that training has occurred and who attended that training and when was that training? And then security measures surrounding your devices. Also gather information to show who you are. Your organizational charts, your employee handbooks, your code of conduct, your privacy postings, your processes if you have a disaster, and your recovery and your notifications. Make sure that you've got that right to the ready and you can show them who you are. Because remember, once you've been notified, you can't further prepare, you can't further update policies, change processes, those kinds of things. It kind of is what it is because you've only got 10 days to show what you got. In regards to a perceived or a validated breach, is there someone identified in your organization who will be notified and again to conduct that investigation? I know I've said it before, but it's really important to not be in a scramble mode when this when A, breach or a potential breach has occurred, or B, if you get asked to produce documents. Standardize your investigation and standardize your enforcement from an organizational standpoint is of utmost important from a reporting safety standpoint. Please know that if a OCR complaint is rendered against your organization, it will have the same process as an audit. Make sure that you know you have your business associate agreements and they're current. Make sure that you have a listing of your business associate agreements. Now we've gone over a lot of information in this presentation and I think we're up against, we've got about maybe quite 10 minutes left. The HIPAA Phase 2 audits and their adherence to compliance are not going away. And so your best offense is a great defense. Be prepared. And if you didn't get audited in this round, you may in the next. So thank you very much for your time and attention, and if there's any questions out there, I'll certainly entertain those.
Great. Thank you so much, Barb, for that information-rich presentation. So before I take our first question, I would like to remind everyone to simply type your questions into the questions chat panel located to the right of your screen, and we'll take as many as time will allow. So as you mentioned, a lot of great information. So we saw in the first poll about 70% of those on the call have minimal understanding. So now that they have this information, what would you suggest they do first when they get off today's call?
Thank you, Nikki. That's a really good thought. And first things first, figure out where you're at. pull off the website that I gave you that has all the protocols and start really looking to see where you're at with those protocols. Do you have your policies in place? Do you have your processes in place that will help you if you get A, audited, but B, these are really what is required to be in the privacy rule and the security rule and the breach notification rule. These are the rules that we need to go by. And so really looking at those and your current processes to make sure that they have a matchup, and then augmenting your policies and your training where needed to pull that together. One of the other things that I think would be very valuable is making sure that you have a good compliance program and that you have your risk assessment completed. And where is that information going? Who knows about your risk assessment? And does it go all the way up to the board? Does your board have an understanding of who is the compliance officer? What information is being monitored? When is it being reported back to the board so they can either ask questions or, if needed, they need to offer you support and tools to do your job? Training. Training is key. Again, the every year training, that is the overarching piece of compliance and HIPAA, and then also the targeted training for those who have a little bit more specialized role, like say in billing, nursing, registration, the physicians, those kinds of things for a little bit more targeted training close to their role. And another piece is, what are you monitoring? What devices are you monitoring? Are they internal or are they external? Passwords. Are you looking to see if there's, a high-profile patient, or you've got someone who has access to everybody's record? Are you looking at to make sure that they're accessing those records for the use of their work role, and have those policies in place to make sure that those things are being audited? What are the other audit information pieces that are being brought forward, again, up through, whatever committee that you have, and then up to the board, so the board knows exactly what is being audited and monitored in the course of your compliance program. So compliance program is key. The policies and procedures regarding the 189 protocols is key in making sure that you have a good rounded process. And again, not to ramp up and say, oh good, we've got this done, this is already done, but it has to be an ongoing, this is how we do business, this is how we have our code of conduct, this is how we do our compliance, this is how we do our protection against privacy and security and breach.
Great, thank you for that information. We had another question to come through from Louise. She asks, how current do the business associates agreements need to be?
That's a really good question. In our world, we say if you haven't had one within the last 2 years, to go ahead and get a new one. So if you've got one, if again, like the example I gave, they hadn't updated theirs since 2005. They did have some language changes that took place, and so everyone who had a business associate agreement prior to 2010 or 11, I believe, needed to have a more current one. What we say is that if it's been 2 years, you may want to circle back around and get a new one again, and it's twofold. One, to make sure that you have a current agreement, but two, are you really looking at your list? Do you need the agreements that you have with? Are you still utilizing their services, and are they doing a good job for you? And so you want to make sure that you're evaluating those who you have a business associate agreement with every year. Are they doing a good job? Are they doing what they said they were going to do? Are they providing the service that you want them to provide? And that's just another way to evaluate that business associate, and then bring those evaluations again to whatever quality committee or privacy security committee that you have, saying, yes, these are the business associates that we have, we've reviewed them, these 35 are really good and we want to renew because it's been a few years. Just for the language component pieces, if there's always different language, and that's in regards to let's say notifying a covered entity regarding a breach. Well, is it the attempted of a breach? Some of the old language says attempted breach. Well, some facilities have an attempted breach 500 times a day, but they were never successful in accessing. And so if you were needing to report 500 times a day to your covered entity as a business associate that you were, potentially breached, but you weren't, there's some language that has been, augmented and changed saying, gosh, if, and they have new words, pinging and different new words that describe an attempted hack. And so you just want to make sure that you have, the up-to-date language in your business associate agreement as well.
Very good. It's a
I hope
very
that helped.
Thank you. And if it didn't, feel free to chime back in. But it sounds, I mean, this is a very fast-moving and never-changing environment, and the tools and processes that we have in place to address and support them sounds like they have to change just as frequently as
They
everything
do.
else.
They do.
Great. All right. Well, I want to just close out with a couple of announcements, and if there are any other pending questions, feel free to just go ahead and send those through. I would like to just take a moment to advise of two upcoming events from HFMA. One is the National HFMA ANI, which will be in Orlando, June 25th through the 28th. So you can register by February the 28th and save $150 on your registration fee. Just simply go to hfma.org/ANI for more information. And the Region 8 chapters of HFMA, if I can get my words out right, they're also hosting a Mid-America Summer Institute, which will be in Kansas City August 7th through the 9th. You don't want to miss this. Great information, great education, and a very fun networking event that they're planning at the Royals and Cardinals baseball game on August 8th. So there are some sponsorship opportunities. If you'd like to get your product or services in front of this great group, I think they will open up on March 18th actually, and then registration will open on April 1st. So be sure to check their website, which is hfmaregion8.org, for details as they become available. So one quick note, there, I was just about to answer that, Teresa, because a couple more asked about the presentation. So just know you can get that right now. Just expand the handouts section of your floating panel to the right. Click that plus sign, select that PDF icon, and you will have access to these information-rich slides that Barb shared with you today. So as we approach the top of the hour, I do want to take this time to thank our members and the healthcare community for joining the call. As you exit, you will be prompted with a survey. We would love your feedback about today's event, as well as topics that you'd like to hear on future events. So please stay tuned for information for registering for our next educational webinar. So Barb, thank you as always. It is always a pleasure to work with you, while you share your knowledge with everyone. Any last words before we adjourn for the day?
Well, thank you. I just thank you, Nikki. Thank you so much for being the facilitator and the moderator today, and thank you all for allowing me to present this very important topic. And if there's, again, any other questions, just please let Nikki know, and she'll forward them on to me or reach out, and we're here to help. So thank you very much.
Thank you, and thank you to Craneware as well. Have a great afternoon. There you go. Oh, I'm so.
I just want to correct.
Thank you. I'm looking right at your logo, I Bailey. For some reason that came out. So thank you for allowing them to share you with our audience today. And we look forward.
Oh, absolutely.
Thank you. And we look forward to everyone on the next call. Have a great afternoon, everyone.